All right. We will go ahead and come to order at this time. This is the House Judiciary Committee. We are taking up a few bills today. If you would, please choose to join me in prayer at the beginning of our meeting. Dear Heavenly Father, we thank you for this opportunity to work on behalf of the people of Georgia and focus on policy matters before us today. We ask for your looking after the people in Ukraine currently as they are under attack, and ask for your grace and mercy. In Jesus' name I pray, amen. All right, so what we'll do at this time is go ahead and work through the bills. With the first bill we'll consider is House Bill 1350. I see Representative Wade here. If you'd come forward, Representative. Just procedurally we're doing is we're moving this bill up from the subcommittee. We've had a few substitutes that have been before us to consider along the process. And if you would just read the LC number that you're working from and go and present your bill, we would appreciate it.
Thank you, Chairman. Committee members, working off of LC 442049RS. Is that
yes,
correct
sir.
for y'all? All right. So I appreciate the opportunity to work on this legislation, and it's really not thankfully, it's a short bill, not a lot of updates. This bill addresses two things. First, we experienced an issue back home where there were some beneficiaries that did not receive any notification and were unaware of a person who is in my community who passed away's intent to leave those funds. And the executor made a choice to not fully complete their duties, as I believe most people see that duty. And the beneficiaries had no idea, and the executor never notified them. What this bill would do is to make sure that not only heirs are notified by an executor or administrator of a will, but also that we would add language to include beneficiaries. We also wanted to make sure that we didn't overtask the probate court. We did not want to make them the policeman, if you will. The goal is for them to make sure that when the 30 days, if you look at with me on line 19, this is kind of the major change. Within 30 days following the issuance of letters of testimony or letters of administration, that would be the kind of the starting time as to when they need to provide that. And this was language that those groups provided that they were comfortable with and that they appreciated. And we also did not require. The major change from last subcommittee was originally we were going to require the probate court to review those documents once submitted. And now this will just merely maintain those documents for retention purposes. And it would not prevent a probate judge, should they make a decision on their own based on relevant information in that community. If they wanted to review those documents, then obviously as a probate judge, they would have that discretion. But this ensures that that's not a requirement in the probate courts and their association. I'm understanding the bar folks were also very comfortable with that. The second thing this does is just does a little bit of cleanup in the investment management account world as we're dealing with the uniform transfer death security resignation. This is a request by Georgia Bankers Association, and I believe my understanding is the credit unions are also in favor, and investment advisory associations in this state. If you'll notice on lines 47 through 51, it just also cleans up to ensure that those accounts who have been treated similarly as all the other accounts within securities have the same standing as it relates to beneficiary. So with that, I'm happy to attempt to answer questions. I also want to tell the chairman I appreciate all your help and guidance in getting to the right folks, as well as some of the other co-sponsors on the bill. This, as a community banker, this is me putting my toe in the water. I deal with this from a practitioner standpoint, mostly in the area of Section 2. And I've had clients that have had to deal with the states, but I've never been on the front end of that issue. And I've never been an executor. So and this was a learning opportunity for me as well. And Chairman Scoggins and Representative Gunner, I always want to call him Judge, were very helpful as well. So with that, I'll answer any questions.
Well, thank you, Representative Wade. So I know Chairman Scoggins, Chairman Gunner, and Representative Kelly have spent a lot of time really working, trying to work to address the issue that was brought to you, Representative Wade, with a constituent concern, really.
That's right.
And I also want to thank the Probate Judges Council for the input given. There has been some additional input that's been given since the substitute was released. And that is, we've attempted to address that with this amendment, which is here. And I just want to alert the members to that as you're reviewing this bill. That's what it corresponds to. But there are a few questions. Sure. Representative Smith.
Thank you, Mr. Chairman. Representative Wade, appreciate you dipping your toe into this. I actually am involved in some probate litigation that gets right at this very issue. And kind of curious, I mean, it looks like there are some good requirements here, but it would seem, and you tell me if you agree, it seems like there's already a way to deal with this, especially with the issue of a fiduciary, the executor acting as a fiduciary. There's already some remedies that law available to fix what you're trying to do here. Would you agree?
Well, I would say that based on the constituent concerns and from the folks that I talked to in my community, the probate judge of my district, actually both of the probate judges in my area, they preferred a strengthening of it on the notification side to make sure it was clearly stated. So I don't know that it necessarily changes any current remedy that law allows, but it definitely provides an improvement to ensure that any beneficiary, and specifically in our instance, it was nonprofit. St. Jude's was the named party that was supposed to have received funds from this person's will, and they never received any notification. And so, anyway, I'm not disagreeing with you. I think this just provides an extra level of clarity that my probate court folks and my community was requesting. So.
Sure. Well, I understand that, but I would submit to you, Representative Wade, there's already a remedy for these type of situations, and it would be the removal of the executor as the fiduciary of the state. And I can say this, having dealt with this in practice, there was a thought, there is some strategy to this. Almost found myself in a situation where I was going to have to file that. The good thing was the executor realized that they were in over their head, and then they went and did the appropriate thing and hired counsel to help them in the administration of the state. So I would submit that you already have a remedy available at law.
Well, the remedy that I'm trying to seek is the notification of beneficiaries and heirs as an equal. And so the attempt of this bill is not to necessarily go after an executor that makes poor choices. Mine is to ensure that any executor, maybe the level of their willingness to serve, will be given notice that in my community, most of the folks that are dealing with wills, they're not extremely complicated. Occasionally they are, but we do have a lot of folks that will leave, property and some assets to children and their direct heirs who are human beings. But occasionally they may have a nonprofit like a Rotary Club or a Lions Club, as well as a church, or in this instance, it happened in my community, St. Jude's, that wasn't named, and none of the parties that were beneficiaries, that just happened to be the largest one. So again, I think it would just probably add strength to the point you're making. If an executor were to choose not to do so, then that would be one other area that you would have evidence that they did not provide notice, would be my intent.
All right, Representative Scoggins. Is that you, Representative Oliver? Representative Oliver.
Removal of the executor, I'm afraid, is going to come after he or she has stolen the money and sent it somewhere else. And so many executors are not bonded that the provisions that Representative Wade are setting forth are more proactive, and yours, the existing law, is retroactive for an executor who is, you can't recover anything after she has messed it up. The reason when I administer estates, it's my practice now to notify beneficiaries because it ends up protecting me more down the road, particularly if they are charitable or sophisticated folks that I think are going to be watching, particularly if I'm selling estate property. I want the beneficiary to be upfront in the get-go, to know what I'm doing, to know I am bonded, and to know that the beneficiary down the road might have a chance to object, but I would rather the beneficiary up front tell me your price is bad, your price is good, blah, blah, blah. So I see this additional duty of the executor to be a protection for the executor and a protection, obviously, for the beneficiary. And going after executors who've already stolen the money and who've vamoosed and not bonded is waste of energy on my part, which I've done that waste of energy. So I'm sensitive to it.
Yeah, and ultimately, I didn't necessarily want to go and address the existing law that Tyler Paul, Representative Smith is discussing. I felt like that, once there is a fiduciary responsibility that's been breached, there is, I think, appropriate, the law appropriately allows for the retroactivity that you discussed. Representative Oliver, I appreciate your thoughtful comments.
All right.
I did, Mr. Chairman, what I don't understand is the investment thing. I just don't understand. I hadn't gotten it yet, what it is it's supposed to do. And you may want somebody else to testify.
Sure. I don't know if the member from the Georgia Bankers Association is here.
Okay. That's okay. We'll kind of take issues one at a time. So Representative Kelly, did you have a question online?
Thank you, Mr. Chairman. I was just going to kind of make the point that Representative Oliver made, and that's that she stated it more eloquently than I could. So I'm going to defer at this time.
All right. Thank you. And thank you, Representative Kelly, for your work on this bill.
Agreed.
Representative Holcomb.
Thank you, Mr. Chairman. Just a question / concern on the new paragraph B beginning on line 47 into 52. The only thing that gives me some pause about how this is written, I understand the intent, is the clause on line 48 of or any other type of account with a bank or trust company, but all the preceding references are to investment accounts. And investment accounts typically aren't held with banks. They're held with brokerage firms or investment advisors. And so I don't know if we want to clarify that because I could see attorneys saying that or any other type of account with a bank or trust company relates to the items before. And I don't know if legislative counsel has an idea on how to sort of clarify that some more, because what I wouldn't want to have happen is somebody say that all these types of accounts, they're not held in banks and trusts, and so it doesn't apply.
Well, I can speak to this as a practitioner, as a community banker for over 25 years. In my entire career, I always tell folks I started out as a teller and I've worked my way down ever since. That was supposed to be funny. It's okay, y'all. It's Judiciary. We need to laugh. But when I was opening accounts as a customer service representative and helping clients with certificates of deposit, or in some cases annuities, depending on the financial institution, savings accounts, very often, especially in the communities that I've been in, people specifically want to name a beneficiary on the account. And, by and large, that's usually a spouse or a child. In some cases, it's a niece, nephew, close related, but those beneficiaries are named specifically under what's payable on death. And occasionally, sometimes those things get crossed with when there's a probate file, when there's not. And this is making sure that what's been in practice for many years for community banks meets the objective of a beneficiary status. That's my understanding as a practitioner, and I'm not an attorney. So if legal counsel and the folks from the Georgia Bankers Association want to come and provide any additional clarity to clean up your concern, I welcome that at the chairman's discretion.
So what we'll do is we'll just consider section 2 at this time. And Representative Oliver, if you have any questions about it, of course, we'll take those up. And I'll ask Elizabeth Chandler with Georgia Bankers to come forward and give us any testimony she might have about the bill.
Thank you. Good afternoon, Mr. Chairman and members of the committee. As you said, I'm Elizabeth Chandler, and I work with the Georgia Bankers Association, and we appreciate Representative Wade's willingness to take a look at this language and hopefully include this. Just as a little more background on where this comes from, in 1999, the Georgia General Assembly passed the Uniform Transfer on Death Security Registration Act. And since that time, well, that covers securities and securities accounts to be registered in beneficiary form, which designates the present owner's intention that the security passes to the beneficiary. So as you all know, that creates a non-probate transfer. And the underlying act has been passed in all states except for Texas and Louisiana. Since that time, a number of states have amended that underlying act to include bank management investment accounts or custodial accounts. And that's what we're seeking to do for the benefit of many bank customers. And in addition to those type accounts and those type banks who may hold these accounts, there are also a number of banks that are in trust services work in Georgia.
All right, Representative Holcomb, any follow-up questions for the language concerns you raised?
I don't know if they have a thought. I mean, my thought would be to just delete other type of on line 48. So that way it doesn't raise any issue that we're just limiting it to those type of accounts with banks or trust companies. And then you're probably fine of having the investment management account, investment advisory accounts. Because like I said, usually banks may have that component, but it's not actually a bank account. It'll fall under their broker dealer or under their investment advisory arm and under the bank account. So I just want to make sure that we're clear in the language of these accounts, because securities aren't kept in like checking accounts or money market accounts and things like that.
That's correct.
All right, so we'll take up amendments in a minute, but I guess what you're, well, I'm gonna repeat back what I think you're proposing. You'd add an or before custody account, and you would strike or any other type of account from line 48.
Chairman, at the appropriate time, I do have some language for consideration to address his concern.
Okay.
And the Georgia bankers are comfortable with it.
All right, go ahead.
All right. So on line 48, when you get to the comma after custody account, where it says any other type of, between the word of and account, right, security or trust account. That way we're making it specific to those two types, which are the ones that we're trying to ultimately get at. I think that would be sufficient for my intent as a legislator and as well as
to the best of my ability.
Yeah.
Okay, so the proposed amendment would be before the word between of an account,
yes.
Add security or trust.
Yes.
All right. Any other questions or comments about section 2 before we focus on section 1?
I think so. What is a trust company? Oh, Lord. Let's see. Let me put on my.
I'm looking at line 48, 49 in paragraph B. What's a trust company?
I believe it's defined in Title VII. I don't know exactly where. It is a set of powers allowed for by the banking department.
Daniel, will you go research that, see if in Title VII there's a definition of trust company? That'd be great. Thank you. All right. Any other questions or comments about section 2? Okay. We will move back to section 1 now, and I'll summarize this handwritten amendment. The concern raised since we received this substitute was that there may be a circumstance where a beneficiary wants to waive the notice requirement, or maybe there are circumstances where it seems ridiculous that notice is to be provided, and it would make sense for a waiver mechanism to be in the statute. So a few minutes before committee, we met in my office with legislative counsel, and for anyone listening online, the proposal would be on line 25 after the word representative period, insert provided, comma, however, comma, notice shall not be required to a beneficiary if waived by that beneficiary in writing, period. And then at the end of line 26, add waivers and.
Of such waivers and notices. Yeah. Okay. I'm amenable to that change.
Okay.
Yeah, that's not a problem.
All right. Well, here is what I want to do. We will, Representative Wade, we'll ask you just to scoot a place or two over here
Sure.
at the committee table, and we're just going to suspend while we get an answer for Representative Oliver's question
Sure.
to get a definition out of Title VII.
Okay.
And then we'll be ripe to take up your bill in just a moment. Representative Holcomb.
Mr. Chairman, I may have a solution to that, but which Representative Evans made a suggestion offline, and I agree with her, would be on line 48 to just clarify it to where it's or any other security or trust account, and then delete with a bank or trust company, because then it doesn't matter who's holding it. It just is the types of accounts that we're talking about, and it resolves the issue that I raised in terms of these accounts typically aren't held by banks. So let's just get rid of the reference to with a bank or trust company.
Does the sponsor want to confer about that, or?
Let me give you this opinion as a banker. Since there is code in Georgia law that allows for banks to have a trust department, I don't think that it is opening up unintended consequences by referencing it as a trust account or a security account within a bank or a trust, because those are limited by those banks that have trust companies or a partnership thereof. So, again, I'm not an attorney, but I think that from a language standpoint, because trust companies do exist in Georgia and we have existing banks that have those departments, they are, in some cases, those accounts are literally in that bank via a security account or a bank account that is approved under the department. So if we need to get more clarity from the Department of Banking and Finance, I'm sure we could probably do that. Possibly the definition of a trust company might benefit that discussion. So I'm open to other folks that have more experience from the legal side on this, but I know we do have banking partners that are members of the Georgia Banker Association and the Community Bank Association that are and have trust companies. So
let's do this. Let's suspend on that bill for just a moment. Hopefully we'll get a definition of trust company from statute, and that can be provided to Representative Oliver and any other member that wants it. All right. Okay. HB 1321, which was on the agenda, we are going to delay that bill from today, but I'm going to add a bill onto the agenda that was just assigned to our committee on Friday. It's House Bill 1499, which was just handed out. This bill would create a 7th state court judgeship in Gwinnett County, Georgia. And it was introduced with bipartisan support. It's before you today as it was introduced without change. And I have personally participated in meetings where the Gwinnett County government has expressed support for this and willingness to fund it. It's all county money, no state contribution here. Be happy to answer any questions. Representative Smith.
Just at the appropriate time, Mr. Chair.
Now is the appropriate time, sir.
Mr. Chair, move do pass.
All right, there's a motion do pass and second on House Bill 1499. Any amendments or discussion? Hearing none, all those in favor signify by saying aye.
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 Any opposed? All right, very good. It's on to rules. Thank you all. All right, so what I'm going to do now is recognize Brock Perry, our staff attorney, who can give us the definition of trust company from code.
So under Chapter 7 of the code, line 40, it says trust company means a corporation existing under the laws of the state on April 1st, 1975, or organized under this chapter and authorized by law to engage in the business of acting as a fiduciary.
All right, very good. Let's see, Representative Oliver's out. Maybe what I'll do is ask the sponsor if you'd like to respond.
sure. So, after talking with the representatives from the Georgia Bankers Association. At this time, we are comfortable with if it's amenable to keep the amendment that I suggested after of an account being security or trust. And if it needs to remove the word with a bank or trust company at this time, if that is something that is required by the committee to make them feel more comfortable, or if the language is with a bank, if that is more now that you've had trust company defined, I would be okay with primarily removing with the terms a bank and leaving trust company now that you understand trust company is defined as a fiduciary relating to these type of accounts. I would be amenable to that as a primary request, but if you have to have the word trust company removed, I would ask your justification, but if that could stay, I would think it makes sense now that you've heard the definition. So I would put it that way. If a bank or is removed, I'm comfortable with that if you guys are, because the trust companies would be covered under the definition based on the trust. So,
all right, well, here's my proposal. We'll see if the committee's ready to move forward with the bill. We'll take up the section 1 amendments if those are appropriate to do so, and then we'll allow plenty of discussion for amendments in section 2 as necessary,
okay.
so that
thank you.
we can give feedback. And I think we're having a productive discussion here. All right. Question now is there a motion with respect to HB 1350 committee substitute LC 442049S? All right, so a motion to pass in a second. First amendment is proposed by the chair. This is to add after the first period on line 25, provided, however, notice shall not be required to a beneficiary if waived by that beneficiary in writing, period. All right. Is there a second for the amendment? There's a motion, a second. Any objection to the first amendment? All right, hearing none, it's adopted. Second amendment in section 1 is at the end of line 26, add waivers and. Is there a second? Any objection to the second amendment? All right, very well, it's adopted. All right, any other amendments with respect to section 1? Any other discussion about section 1? All right, now we'll move on to section 2. Any amendments proposed for section 2? Representative Holcomb.
Thank you, Mr. Chairman. Can we have a discussion on this real quickly first? Can the committee rehear line 48 of what y'all proposed just to make sure that we're all on the same page?
Are you ready?
Yes.
So line 48 would be agency account, custody account, or any other type of security or trust account with a trust company, including the securities in the account, the cash balance in the account, and so on.
Okay. All right. So it would be to add security or trust between of an account, and strike bank or.
Yes.
Okay. Yeah. If y'all like to come forward. Chandler, if you'd like to use the other committee chair over there for a microphone, that's fine.
Thank you, Chair Registration. I'm Lori Godfrey with Community Bankers Association, and I actually used to work at the banking department, so I'm have a little bit of knowledge. We only technically have one trust company chartered here in Georgia, Reliance Trust Company. I think that's still the same. For a bank, you have limited or you have full trust powers, but most of our banks are going to, you elect to have them when you set them up, or you can apply for trust powers, but it's not, I think the better word there would be bank, okay. In my opinion, but I'll defer to Elizabeth.
I agree.
Okay.
Which gets back to my original point, not to, discredit Representative Holcomb's concern. I appreciate it, but it's very limited when you put the term security or trust account within a bank or trust. It is a very, very small, narrow number of accounts that would have to fall into those type categories.
Yeah, I think I appreciate that. And if you want it really, really restrictive, that's totally fine. And I don't have an objection to that. It's just, that's a very small universe that we're talking about, because like most of the preceding types of accounts aren't held with banks. And so just know that you're being very, very restrictive in drafting it this way.
Yeah, that's the intent of the correction.
Okay.
So can I give you a separate, more updated amendment based on that testimony? So on line 48, we would continue agency account, comma, custody account, comma, or any other type of security or trust account with a bank or trust company.
Chairman Burchett.
Representative Wade, is there a reason that you didn't, I think you proposed it or someone proposed it, that we would just say, leave the bank or trust struck? Was there a reason for that?
That was Representative Holcomb originally, before we got the definition of a trust company and before we had the testimony from Ms. Godfrey and Ms. Chandler.
Representative Holcomb.
Ms. Bickle, you want to come forward as well? It's okay. No, we appreciate you being here. If you'd like to sit at the.
No, and I appreciate all the dialogue, and I appreciate the bill sponsor as well. And with you saying this, Brandy Bickle, Georgia's own credit union. We are a credit union. We are a federally insured financial institution. We are not a bank. I don't know if this in the world wraps us into that, but just please keep that in mind with whatever you guys look forward. And it was not my intent to derail or extend, and I was going to come talk to you later.
Sure. So, and I'm not of the, I don't know that credit unions have trust authority. That's the only reason that they're not included in this. It wasn't necessarily to exclude them, it's because of the specific type of accounts. But so just for clarity, if that was a concern you had.
It helps the process. I wanted to say something now as opposed to later.
Thank you.
You have any follow-up?
I'm just, if we don't limit it, then it's more broad in that we don't have bank or trust company. And you're not concerned with that?
I mean, I would say that in order to try to help both of the folks that are here representing organizations that had requested this change to help clarify, mostly specifically banks that are dealing with the trust departments, I think having it qualified makes sense. But I'm okay. I think it's actually appropriate to leave. And I like the change of defining it as a security or trust account with a bank or trust company. I just think that narrow definition actually meets the overall objective within the goal of that beneficiary type account that's already vested with lines 43 through 46, if that makes sense.
Thank you.
I think the rest of the universe of these accounts are probably already covered under the underlying uniform bill.
All right. Any other questions? Okay. So what I'm hearing is a proposed amendment between the words of and account on line 48, add security or trust. Is there a second or any objections to that amendment? Hearing none, it's adopted. Any other amendments or discussion? Question now is on HB 1350 LC 442049S with the 3 amendments that have been adopted in committee. All those in favor signify by saying aye.
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 Any opposed? Very good. It's on to rules. Well, thank you, Representative. We'll get you a Rules Committee form signed before you leave here.
All right. Thank you.
For planning purposes, it looks like we are going to need to have another committee meeting in the first half of this week. I just don't know exactly when that will be. It's possible it will be a morning, like 8 a.m. So just as soon as we know, we will get notice out. We're just waiting on some substitute language drafts, and we'll try to give you as much notice as we can, but we appreciate your understanding with crossover day being next week. So thank you all. We are adjourned.
Thank you, sir.